Good afternoon, everybody. Thank you so much for taking the time out of your afternoon to make it today to effective contract review. We have a wonderful presentation ready for you here today. As Jennifer stated in the chat, please take this opportunity to welcome yourself in the chat, as David has done as well. Just your name, your company name, and your trade. We want to see everybody who's able to join us today. And let's keep going. Just to go over some participation requirements. If you have a question, please use the Q&A feature to submit your question. We'll try to go through the questions as they come, but you might have to wait till the end for your question to be responded to. And please be an active participant. We want you to get the most out of these sessions, and these sessions are designed to help go over general concerns you might have in contract review. But if you have any questions we can respond to, please be sure to use the Q&A feature or the chat. Okay, I'm going to let Jennifer take over now and begin her presentation. Jennifer, are you ready?
Hi, I'm Jennifer Elmore, and I'm the project manager for Merriweather and Williams, a hub company. And here we're to talk about contract review. Next slide, please. So the information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials available are of general informational purposes only and given as a result of Merriweather and Williams, a HUD company's experience working with small and emerging contractors. This webinar is not to be construed as a substitute for review by legal counsel and other professional advisors. It is our recommendation that contractors should have an attorney review all their contracts. The purpose of this webinar is to give you some insights into your contracts and how contracts affect your relationship either with an owner, a prime contractor, and as I saw from the chat, a developer. And I usually try not to read off of the PowerPoint, but this one I have to read verbatim. So next slide, please. So today's objective is to address contract review. And what we're trying to do is get you, if you haven't done this before, recognize certain words and terms and how they impact how you conduct your business. Next slide, please. So at the end of this, we will provide a checklist. And what I'm going to do is periodically check in with Merriweather and Williams and see if they will check for any questions in the Q&A. I'll hold for a second to make sure that you get your questions answered. And we will provide you the checklist after this seminar for you to have. So when you're looking at your contract, there are sections to read for accuracy, sections to review, and sections to pay close attention to. In some instances, you may be able to negotiate your contract, or as I call it, push back on your contract, but sometimes you can't. So forewarned is forearmed, and that way, and usually contracts are given out a blank or a template is given out before you bid on the contract. So what you're going to do is, next slide, please. So first you're checking for accuracy, scope of work. And this is one of the things we see oftentimes with our subcontractors and contractors is that you're going to want to know the definitions section to understand what is in the contract and what they mean by it. And a simple definition is, for example, in a contract, is it calendar days or business days? That is one minor small thing that you should check for, because when, for example, they're asking for a change order and they give you 5 days, are those 5 calendar days or 5 business days? You're going to want to make sure that when you provided your estimate that the inclusions and exclusions are in there. It's most of the time what they do is they take your scope letter and they attach it to the contract as the scope. But if they don't, you want to review it to make sure that everything is the way you submitted it and they haven't deviated from it. Then you're also going to want to look at a project overview. You're going to want to make sure that what you bid is what's in the contract. Make sure the contract amount is the same for what you bid. If there's changes, then you need to know why and what was omitted. You're going to then want to know milestones and deliverables, and that is about timing. Are you going to hit all your timing as you need to? And what are the consequences if you don't meet your timing? The prime, the owner, the developer should provide a schedule and timeline. Does that comport with what you bid on? And then you're going to want to look at the management and administration requirements of the contract. Management and administration requirements can be anything from the timing, from what you have to do, how you process your progress payments, and we'll go into that in more depth later. Next slide, please. Okay, so we're still in the read for accuracy section. So when you read your contract and you are a subcontractor, for example, you not only include your contract, but there's other contract documents that are included. The slide is a little bit off. So when you have those for example, when you bid as a subcontractor and you enter into the contract, part of that contract will include all the drawings, the specifications. It will include the contract from the prime contractor and the owner. All of those are part of your subcontract documents, even if your subcontract is only 10 to 15 pages. Hello? We're having a technical moment. If you could give us a second. And Rena, if you could have Matt Drewski removed from the event, that would be really wonderful. And I agree with you. Yes, it is often the architects and engineers firm as the owner's representative as well. Rena, we have two people with their hands up.
My apologies, everyone. Can everyone hear me?
Yes.
Beautiful.
You want me to try to save it? Can I do that?
Save.
Here.
Yeah, I can share my screen too. But
Okay.
my apologies, everybody, for the delay. We were having some technical issues. Everything should be okay now.
There
Let
were
us know.
two people with questions or would raise their hands. Do you want to?
There was one person, Ray, who just said that they could hear us in the Q&A.
Okay.
Any other questions in the chat?
Yeah, there were two hands raised, and it was for, let me check. And thank you for removing that gentleman.
Yeah. Barbara,
Okay.
you had your hand raised? Slides will be sent out after the presentation, as well as a recording of the presentation.
Hopefully edited for not the technical error.
Yes.
Okay. Oh, it'll come back to you, Barbara. Okay, so I'll get started. So we are now on what you want to check for accuracy, dispute resolution. So what you're going to want to know is what type of dispute process that you've got in your contract. Is it mediation? Is it arbitration? Or is it litigation? Nowadays, it's usually mediation or arbitration, and mediation is a third party comes to help resolve the dispute, and it's a professional mediator, but it is not usually non-binding, whereas an arbitration takes the place of a judge, and it is usually considered binding, and they hand down a decision. Litigation is what most of us are familiar with. That is, civil litigation. One of the things in your contract is you're going to want to know who pays for the mediation, who pays for the arbitration, and who pays for the litigation. What will happen if someone loses in either of those cases? Who's going to pay for the claims of dispute? You're also going to want to know what state law governs. So, for example, if you're in Utah and the project or the prime is from Utah, but the project is in North Carolina or in California, you're going to want to make sure that, California law prevails, hopefully, or if Utah law prevails, that, and here's a second part of it, that you can have the court case in California instead of in Utah, because if there is a dispute, you do not want to be going from California and or North Carolina to get to Utah to dissolve it, because that already brings up the costs. Okay, next, please. So then you want to review what we call contingent payment clauses. So there are two clauses usually in contracts, and they don't state them exactly this way. It's pay when paid or pay if paid. And what they do is they determine how you get paid, and not how, but when you get paid. So pay when paid language states that the subcontractor will be paid after the owner has been paid. This language is not allowed in all jurisdictions. And when it is allowed, pay when paid, then what you need to look at is what is a reasonable time for you to have to wait. And usually the timing is then regulated by the federal, state, and local prompt payment laws. And then the other is a pay if paid clause. And that creates a dependency between the owner, the general contractor, and the subcontractor being paid. And it shifts the responsibility of non-payment from the prime contractor to the subcontractor. Request this clause to be removed because it means if they don't get paid, you don't get paid even if you've done the work. Now, one of the nice things about this clause is it is not allowed in California, Delaware, Illinois, Indiana, Kansas, Montana, Nevada, New York, North Carolina, Ohio, South Carolina, Utah, and Wisconsin. But to double check whatever jurisdiction you're in, all you have to do is Google prompt payment laws, put your federal, state, or local, wherever you are, and that will tell you, one, what is a reasonable amount of time for you to wait. So for example, in some jurisdictions, you have, if the prime gets paid, they have 10 days to turn it around or 3 days to turn it around. And then also it says it'll then inform what is reasonable to receive payment. And then it'll also tell you if they allow for pay if paid clause, which you want to get rid of in all cases. Next question. Next slide. Sorry.
We have two questions. When a
Sure.
broker insurer lists the policy indemnity contract for insurance as we are not part of the California pool of insurers, does that mean A, claim on policy contract is accepted but processing will be done outside of California? Or does this mean I will have to secure counsel outside of California for my California event based on the language? We are not part of the California pool of insurers.
Okay, let me look at that. Insurance. This one I'm going to have to get more information on. Rena, can you save this question and the person who asked it and make sure that we get more information?
Okay. Friends of Watts Tower Art Center, also, if you want to email us this question too, we can email you back our response for this.
And we'll make sure we get it to you by tomorrow morning early.
Thank you.
Okay.
Bruce asked, these clauses are still in CA construction contracts. What are the penalties if they do, I'm sorry, these clauses are still in CA construction contracts was Bruce's question.
Okay, so the pay when paid is going to be part of the California construction contracts, which is permissible in California. Pay if paid isn't, and what I recommend everyone do is they go to the prime who's doing it and let them know it is to have it removed because it is not allowable under California law. So this is the part where usually you can negotiate because it's contrary to what is allowed. There are still some prime contractors or developers that come from out of state that do have these, and those are where you would push back on it. Okay, what are the penalties if they do not pay per state prompt payment laws? So there should be penalties, but this is usually regulated at the local level. And I would check how it is in that specific locality. But this is where a civil rights division or a contract compliance division is there to help you to make sure those prompt payment laws are enforced. Any other questions? Okay, next slide, please.
There's one,
Okay,
I will send language, please send. I'm not sure, Rudy, if you had a specific question that you wanted Jen to answer, but if you wanted to reach out to us via email with a question, we could also help you out there.
absolutely. Perfect.
And then Jeremy is asking, if it's prevailing wage, doesn't the DIR oversee prompt payment enforcement?
So the DIR is, and prevailing wage oversees prompt payment enforcement for the workers, but not necessarily that California statute for, because in California, the prompt payment clause is for 10 days. So it's not DIR who would enforce this. This is more something that you would get from the public entity with whom you're working, the person who does the contract compliance on the contract. Next slide, please. Oh, no. Next
And then,
slide. Go
yeah,
ahead.
the last question was from the previous point about not part of California pool of insurers. I'm not sure what you're referring to. but-
That's from the original question that was asked, and we're going to get the answer to.
Okay, no worries.
Yeah. And we'll make sure we get that answer. We'll start working on it after this. Okay, so the next is you're going to have two potential clauses or a three or even more in this, but what you'll see the most is termination for convenience or termination for default. And what this does is it provides recourse from an owner or a prime contractor to terminate the project for their own purposes. So terminating for convenience arises when continuing with the project is, for example, not financially feasible or desirable, and they've already entered into the contract, but they need to stop it because it's no longer feasible or it's not convenient. And then one of the things you want to see if you can do is if you can get mutual termination for convenience. Most of these contracts are usually one-sided, and so what you want to do is make sure that there are two sides so that you have the right to terminate for convenience as well. So a termination for default is the complete or partial termination of a contract because of contractor's actual or anticipated failure to meet contractual obligations. So what we want you to do here is when you see this termination for default in the contract, we want you to spend the time to read and understand what may trigger that default scenario and what are the timeline to fix things. So usually it'll say in a contract, it'll give you 3 days, it'll give you 5 days, 10 days to quote unquote cure a default. And so you want to know what that is. You want to know what those contract timings and milestones are to be able to prevent it. And one of the reasons why they're allowed to do this is in almost every 99.9% of contracts, you will see something called time is of the essence. And if this clause, as this clause is in your contract, it means it elevates all the timing throughout the contract to something that is a breachable offense or that you can no longer move forward if you do not follow what they're doing from a timing standpoint. Okay. Next slide, please.
There's a question,
Oh, yeah.
can the prime cover payroll like via joint checks or prime advance funds to help cover payroll for a DBE or small contractor?
Yes. Yes, they can. Now, one of the things and it's perfect, that one of the things about that is that when you have something where they're willing to do it, you want it in writing, you want to make sure that they're doing it for your scope of work and see how much they're charging you or not charging you when they do that. But that is something if a prime wants to do or a developer, they can do it. Okay. So the next is we want you to review in your contract no damage for delays. And And a no damage for delay clause attempts to protect an owner from receiving time-related damage claims from a contractor or a contractor from receiving a time-related damage claim from a subcontractor. Often a no damage for delay clause states that a contractor cannot be reimbursed for costs incurred by a delay caused by an upper party. For example, a subcontractor cannot claim costs for a delay caused by the owner or GC. This means that the lower tier contractors can lose significant amounts of money waiting for upper tier contractors to move the work along, whether they caused the delay or not. Where possible, negotiate this clause to include reimbursement for damages. And, if the delay is caused by an upstream parties. Now, one of the things, this is once again where Google or whatever search engine you use is your friend. What you want to do is put in no damage for delays, the state you're in, and see if it's available or enforceable in your state. A lot of contracts will oftentimes have clauses that are not permissible. So you want to double check to make sure you've got that. Okay. Any questions? And then somebody wrote, can you read what they wrote?
Have one-sided, want to bifurcate contract as part one project has cost overruns and substandard work, will seek to escape from part two project with intent to terminate altogether, penalty clause up to 25% termination fee, no mutual termination.
Okay, so what, Rena, what I'd like you to do is copy and paste that where you can into an email, and we'll respond to those offline. We'll make sure we do that. Next slide, please. Okay. I want you guys to review liquidated damages, but I really want you to review it not from your, not just from your contract, but also from, if you are a subcontractor, from the prime's contract with the owner. So, and liquidated damages or LDs for moving forward, because my voice is a little wonky today, it should represent a fair representation of losses where actual damages are difficult to ascertain. So for example, if the project isn't turned over on time, how much is it going to cost the owner for not getting the shop open or for not having the sewer system done? And they should be fair and not punitive. And so we're bringing this up here, even though we'll go over it later. The way it flows down, there are flow down provisions from your subcontracts. So whatever the liquidated damages are in the general conditions or the prime contractor's contract will flow down into the subcontractor's contract. And that's really important to know so that you can attempt to mitigate those as much as possible.
There's a question in the chat. If a client refuses to negotiate any terms of the contract, take it as is or leave it. Does this give the contractor any legal protection to the clauses they had requested to be modified?
So it doesn't in the sense that it is a unilateral contract, meaning that you had nothing to do with it. And so courts construe, or mediators or arbitrators construe the contract to your benefit rather than the prime's. And so if, I would document, if it becomes a bad situation, I would document that you were not able to negotiate in any way, shape, or form. Okay, next slide, please. Okay, there is something called a no lien clause, and the no lien clause is not in every contract, but this one is really important. What it does is it makes the signer waive their right to a lien or bond claim rights before the work even starts. Now, and I'm sure you're probably already aware of it, but just in case, a mechanic's lien is for private projects and a stop notice is for public works projects, because you cannot put a lien on public works properties. So what this no lien clause does is it essentially says it takes away the protection and the potential mechanics lien and stop notice or bond claim against the property if you end up not getting paid. And so this the question is whether this is enforceable. And in some states, California, North Carolina, for example, it is not prohibited to waive your rights to a lien. So even if it's in the contract, you can still go ahead and do the stop notice or mechanics lien. But I always think try to see if you can get it removed to preserve your rights in every way, shape, or form. Next slide, please. So this is another one, a subordination of the mechanics lien clause. The subordination of a mechanical lien relates to the mechanics lien's priority, which is what may ultimately determine who gets paid first or at all, because if there's a bankruptcy and there's limited assets, you don't want to have your lien rights subordinated. And it just says that the mechanics lien will be placed behind other liens in priority, and you might not get paid even if you have a valid lien. So we recommend seeing if you can get rid of this one clause. There's some questions.
Is a public utility considered public property?
Yes, anything that you build, change, or inhabit with taxpayer dollars is considered public property.
What can I do when the GC keeps pushing the delivery of our scope out? We don't want to stop work, but we want to keep our ability to recover the costs. And it's for a municipality, so not sure.
So one of the things, and we could also, Rena's going to provide you an email address. So in your shoes, what I would do is make sure that you follow the stop notice process in your municipality. And I can go over that with you one-on-one. And Rena, I'll ask that you set up an appointment if that's feasible. You have everybody's email address?
Uh, so there need to be, I think, a note in a program, and then their contractor development manager would be able to respond to the question. But if they have a question for you, they can try emailing you, and then
Okay. And I will provide my email at the end, so you can
yes.
email
So,
me
but
directly.
after those, for everybody who does attend, you should receive an enrollment form to either join our contractor development and bonding program in the LA region, the contractor technical assistance program in the Northern California region, or the Charlotte program in the Charlotte region.
Yes. Okay, next, please.
Okay. B Palmer, you had your
Oh,
hand raised. Do you want to type in your question in the chat?
or they can speak if they want to, because I'm sick of hearing my voice.
If you're comfortable, I'll take them off.
Yeah, that's fine. I am.
Okay. B Palmer, you're allowed to talk.
You have to, okay. I can't hear you. I'm sorry. So I'm gonna keep, go ahead.
Yes, B Palmer, if you want to try putting your question in the chat, then we'll get to you.
So I'm gonna continue down. So we call these are, did you hear something? So
Okay,
this is in your contract. It's called a flow down provision. It's also called incorporated by reference or hereby incorporated by reference. And essentially what it does is it will say that, and then it will give a list of all the documents that are incorporated into your contract. That's usually drawings, architects, engineers. That is your subcontract. That is your prime contract. That is specifications. That is general conditions. So what you want to do is see what's in it, what is now part of your contract, and to make sure that you have all the documents. By legal rights, because you are signing it, you should be able to request of the prime or developer whatever contracts. They may redact it for personal and privileged information, but they should send it to you to let you know what you are agreeing to in your contract. Um, and one of the things that's really important is there may be in the contract two different rulings. So, for example, you may have a subordination of lien in your subcontract with the prime, but the owner's contract doesn't have that, and it says it's forbidden. Which one? Which one is ruling? And usually what contracts often say, and it changes, it says if there's disputes in the contract language, the strictest applies. So that is one thing that is good when you're reviewing to clear up. Yes, an RFI, often an architectural RFI becomes part of the contracts documents. And that's why I said to look at that list, because it'll tell you exactly what is included and what isn't. Okay, next slide, please.
Does any architectural RFI become part of the contract documents even if posed or answered after the contract is signed?
Yeah, yes. So essentially the way it works for RFIs, requests for information, or change orders and modifications, all of those change orders and modifications become a part of the contract afterwards. They're part of the amended contract. Yes. Next slide, please. Okay, so one of the things that's really important is when you're looking at your change order language, you want to know what are the timing requirements, what can be included in change order pricing, what is, for example, what are the allowable markups? Can I include the direct, what direct and indirect costs can I include in the change order pricing? Is there a markup for my subcontractors allowable? And then what happens? Do I waive my rights to a change order if I do not submit in a timely manner? So all of those are really important to know. And then, one of the things is that you also want to know if you have change orders and and you have a surety bond, you want to make sure that you want to know the notification rights for the surety, because they need to know that your price is increasing as it goes along. And then I wanted to bring to your attention that on our Meriwether and Williams Hub YouTube channel, we have seminars themselves on change orders. They're a really good refresher if you hadn't had them for a while. So the one thing that in your shoes that I would attempt to negotiate, if feasible, is if the deadlines for the change orders are too short, that you're going to see if you can extend it. So if they only give you 3 days to do a change order or a field change order, then you're going to want to see if you can get 5 days out of it. And if you can't, you're now aware of it and you can react and do what you need to do to get it in writing. Because anytime you modify a contract or change a contract, it has to be in writing. Okay. What did Stephanie Dixon say?
If you win a bid and you complete bid review, once you receive contract, how long do you have to review before signing so you can get reviewed properly?
It's usually around 10 days, but you can always find out from the prime and ask that question, how long do I have to review this contract before signing? It's always better to be safe than sorry. And one of the things that I did want to bring to you guys' attention about change orders and why it's really important to know the general conditions of the contract if you're a subcontractor is because the municipality, including public works, any type of public works, usually has codified allowable markups in their contracts, and it's a good idea to know what those are, because it'll bolster any argument should the prime push back on what is permissible and what's not. Next slide, please. Okay, so warranty periods. So most construction contracts require a warranty period for their material and labor for at least 1 year. And one of the things, and I don't know if anybody here has performance and payment bonds, but the performance and payment bond covers the first year warranty period and provides protection for that period for 1 year. If so, but one of the things is sureties do not like to see above a 1 year period. It doesn't make them feel comfortable, especially working with smaller contractors. And so, if you see warranties of 5 to 10 years, which you could potentially see on a roofing company, you want to make sure that you know how long the warranty period is, or after the project is completed, how long it's going to be for you to potentially have to come back and fix it. So make sure that the warranty period in the subcontract, yes, that's an insurance vehicle, not a bond. Yes, that is true. You are on the hook for latent defects for 10 years, and you should have insurance to cover that, hopefully, knock on wood. But you want to make sure that the owner's warranty period and the subcontract that you have, the agreement, your warranty periods match. And then if you have a performance and payment bond that is required, anything above 1 year may increase the price of the bond. And so you're going to want to know that in advance and include that in your bid, so you're not paying the bond premium out of pocket. And so review to ensure that there are no errors in the contract specifications. We have seen it before where I'm just going to name them, the public entity, the city and county of San Francisco asked for a 10-year warranty, and what they actually were asking for was a manufacturer's warranty and not the warranty period for the contractor. And so it was an error in the specifications. We were able to get that cleaned up and to assist a contractor in getting a bond. So you just want to make sure none of those errors are in your contract or in the contract documents that are flow down into your contract or referenced in the contract. Next slide, please. So this is something that you really need to review. All of you probably all know this. What is the timing for a payment? What should accompany, what forms should accompany the payment application? What is the retention? Can you negotiate the retention? So for example, if there is a 10% retention, can you negotiate it down to 5? And so also the timing of the payments, you want to look at once, if you're with the owner, if you have a contract directly with the owner, what is their payment cycle? And then if you're a subcontractor, you want to see how fast can they turn it around. It goes back to prompt payment, but you want to see what they have in writing. If theirs in writing is, for example, 30 days, you want to point out by, that the laws in your state say 10 days turnaround. And so you want to make sure that that's covered. You also want to, when you're dealing with this, you want to find out who does payment enforcement on the contract for the city, and then also include them to see if you can expedite it. We also recommend doing the stop notice or lien or preliminary lien process to make sure that you always preserve your rights on every contract. And because that mechanics lien and stop notice process is really important. And what does the contract say regarding slow payment and non-payment? Do you get to collect interest rate? What does it say in there? So those are things that you should really be looking out. Next slide, please. Okay, so protection of work. Who is responsible? So some of the risk mitigation tools that prime contractors and owners use allocates the liability of protection of the subcontractor's work product to the subcontractor. So what they're doing is they're passing the risk to you. And so this clause protects the prime contractor and owner while a subcontractor is completing their portion on a project. So it requires you to fix anything that goes wrong with that portion of the work until it is completed. And one of the reasons why we bring this to your attention is if it is a multi-year project and your scope is only a section of the multi-year, you want to make sure, depending on the trade and the risk, that you make sure that you remove that so you only are only responsible for protecting your work while you are on site. So if you have that negotiating power. And so you also want to have the prime contractor. One of the ways to protect yourself is to have the prime contractor sign off on the project when your section is complete, instead of requiring you to protect your work for the entirety of the contract until completion. And you don't want to have to wait till the owner, architect, and contractor sign off on it. So you want to see if you can get that done early. Another way to protect your business in this type of situation is to keep a daily journal of work performed with documented date stamped pictures. Next slide, please. So indemnify is for another party is to compensate that party for losses that party has incurred or will incur as related to a specific incident. And then another definition is to make them whole as if the loss had not occurred. So to indemnify is to hold harmless, obviously. So one of the things that is most important about the indemnification is whom are you indemnifying? Are you indemnifying beyond your scope? Are you indemnifying the another scope? Are you indemnifying an architect or an engineer, which could cause problem? So you should review and have your insurance agent review the indemnity language and to attempt to limit whom you indemnify. It doesn't make sense to indemnify as a drywall contractor or an electrical contractor to indemnify the architect, engineer, or similar design professionals, or as a design professional to indemnify any of the contractors. If there are problems with the plans and drawings, you do not want to be required to defend it. So what we always recommend on top of kind of seeing if you could negotiate some of that language is having your insurance agent or broker review your indemnification and insurance language to make sure you have sufficient coverage. Next slide, please. Okay, so the key takeaways for this are: one, read for accuracy. There are those three categories of contract review: accuracy, review, and to pay close attention to. Then you want to be aware of the flow down provisions and their impact from all the other documents that are brought into yours. 3, understand the terms. They will repeat from every single contract again and again and again. And then 4, you can negotiate, not all the time, but sometimes. 5, when in doubt, get advice of the counsel. So one of the things that we are now kind of recommending to everybody is to use AI. Next slide, please. Okay. So one of the things that we do is, with your contract development manager is we understand the contract and to discuss and we have strategize with your strategic partners that you have or with us. You can hire a lawyer to review your contracts. And then also you can learn your boilerplate language, and that's boilerplate language is language that you see and again. Once you get that contract, use Adobe, search for the terms that we discussed today. And then also you can take that contract and copy and paste it for an AI legal review. And that can help you turn it into layman's language and for you to be able to protect yourselves. Now, obviously, AI legal review is only as good as the information you put into it, but with time, you'll be able to work with it and figure out how to use it. You know, it's a good way that you can then take that information that you have learned and deal with an attorney so that you can speak to them, and when they speak to you, you can understand what they're talking about and feel comfortable talking to them and feel comfortable protecting your company. Next slide, please. So some of the resources that Meriwether and Williams offers are, we do an assessment and targeted technical assistance. Rena is going to send out the enrollment form after this, and you can sign up. Along with that enrollment form, she'll send out the checklist, or the checklist will be going out when we put together the slides and send you the slides. One of the resources we offer are field support services once you have a project. And we also offer surety and working capital line of credit support. And once again, this is through the contract development managers, and Rena will be able to help you facilitate that. Next slide, please. So we've asked questions along the way, but I'm hoping that, Barbara, you remembered your question, or did I wipe it out of your mind permanently? I'm sorry.
Everybody else, I want to encourage you all to take this time to really ask any questions that you have. Jennifer, oh, okay. Ray asked, is it legal in California to write into a subcontract that after X days with no response, then the contract will be assumed executed?
Oh. I mean, technically you could, but they shouldn't. You should sign it. I'm gonna look that one up and get back to you, because that one just seems like overreach.
If you have any additional questions, please take advantage of Jennifer being here to be able to respond to them. Else have any questions? In North Carolina, is it possible that we ask for too many changes on the contract? Is it possible that if we ask for too many changes in the contracts, that the prime could say that they don't want to work with us?
So that is potentially something that I can't promise it's not going to happen, because you're looking for the work and they're offering the work. But a savvy prime would know that you are trying to preserve your rights, and as long as it's posed as a question, hopefully it shouldn't be a problem. But it's something that you will be able to weigh better than anyone can, because you're there, part of the contract negotiations, and the prime, you know who they are, their reputation, and that's something that you probably will be able to answer for yourself. If you feel comfortable pushing back, then you should, not should, but that is probably something that you should listen to. And then there's another one.
I've been seeing AIA contracts that have capitalized terms that aren't defined. Is there a standard clearinghouse of definitions in the construction industry, or should we be pushing for all the terms to be defined?
You should be pushing for all the terms to be defined. The kind of normal contract that we see all the time starts off with a normal preamble, then it gives definitions. I think that, the definitions should be defined.
Thank you. Next, off topic. Hi, I'm a licensed general contractor currently doing subcontracting work for larger contractors. I'm interested in transitioning into bidding as a prime contractor. Are there specific platforms or websites where I can find opportunities to bid directly as the main contractor rather than the sub? Thank you.
Yes, there are, and it's gonna depend on where you are. What I would do, because is I would start off by putting in the city you're in, and then Google bid opportunities. And then if it's a state you're in, and then other areas, and then whatever your discipline is, whatever your specialty is. If you want to do Department of Transportation projects, I would go to them in your state or where you are, and Google it to see and just put in bid opportunities and then search for those bid opportunities. Another way to do it is to go through Meriwether and Williams and be assigned a contract development manager so they can then help you better hone and find work through that way.
Ruben, just to continue to Jennifer's response and to everyone who's attending here, if you attended and you're eligible to enroll in one of our programs, you will receive an email after this session. I would, if you have specific questions on your business, I would return that enrollment form so we can get you connected with a contractor development manager. Next is working as a sub for a public works project. What are our lien rights, if any?
Okay, so you have a lot of lien rights. What you're going to do is it's called a stop notice. So it follows a similar process as the mechanics lien. You're going to do a preliminary lien, and usually when you're doing it on a public works project, let's say I'm picking on Las Vegas, you would then Google Las Vegas stop notice process. And usually they will have forms. And if they don't have forms, then you can use any form and get a form, and then you will follow their filing requirements. From the 2-week preliminary notice. And essentially what this does is it means that the prime is then notified by whatever entity in that public works process, whether the state, has to then talk to them and find out what's going on.
Thank you. Can JV partners aggregate their bid capacity?
Bid capacity? Yes, yes, and yes, yes. I'm not gonna say, I'm gonna give the standard answer, yes and no. So if you, it's gonna depend on how the JV is set up. It's going to depend on how you're doing that, but technically it should, if both parties are coming in strong and really have a good partnership agreement or a JV agreement, which is delineated, saying how it works, and that should technically increase their bid capacity. There are exceptions to every rule.
Yeah. Ada's asking if we have any templates of contracts that we can use with that they can use with subcontractors with minor changes.
Yes, yes. And I will provide my email in the chat so that you guys
The best way again is, yeah, Jennifer will provide her contact information, but if you are enrolled in the program, reach out to your contractor development manager. If you're not enrolled in the program, get enrolled in the program. And if you have specific questions for Jennifer, you can contact her directly or respond to the email that has the information with the presentation and recording, and we'll get you assistance. William just wanted to comment, I love when contractors or owners state everyone else just signs, why not?
Yeah, that's a really good tactic. I actually appreciate it too. If everyone jumped off a bridge, would you do it too? I'm just asking. Of course, you can't do that when you're in negotiations, so I don't recommend that. So, what type of lawyers review contracts? They're contracts attorneys, but what you want is you want somebody who's a construction contract attorney. It's a little bit different. And so you want to make sure that they understand the construction industry. Okay? Reed, I'm going to leave it up to you to read.
All right, GCs typically list the subcontractor for a certain amount on Public Works. If the GC don't list, then shop around. Is there any recourse?
So usually the way it works is when they list you on a subcontract for a certain amount with a public entity, then they are required to use you and they cannot shop around. They cannot switch a subcontractor without permission from that public entity. So I would take it to the public entity when they start doing that. And the recourse is, and usually it's a contract compliance officer or someone who monitors the project to make sure they adhere to the laws of whatever entity that is.
If a subcontractor doesn't have their own in-house legal counsel, what can a contract reviewer do to reduce the amount of work and billable hours an attorney would need to spend reviewing a contract?
So obviously, having an in-house attorney or even an external attorney to review all contract is a cost benefit analysis. We always recommend erring on the side of the attorney. But what you can do is, you can make sure that you have AI the terms. And so that when they're reviewing it, they're reviewing only the sections you don't feel comfortable with. That is one way to do it. You can also make sure that they have everything in one package instead of piecemealing it. And so that's one way, hopefully, to reduce the amount of work and billable hours.
In a billing audit of a construction company and their project work, including work done by subs, what are the key pieces of documentation would we want to get from the construction company? Also, can we collect documents like their invoices sent to a client or the subs?
So can we get a little bit more on that question?
Okay, yeah, let me read it one more time. In a billing audit of a construction company and their project work, including work done by subs, what are the key pieces of documentations would we want to get from the construction company? So I'm
Mhm.
assuming their sub.
So I'm assuming, I'm not going to make an assumption. So if it is a public works project, you are going to want to get to understand the billing audit. You are going to want to get their prevailing wage. You're going to want to get all their invoices that they sent to the prime, but you're going to want the backup documentation. For example, and you're going to want a lot of their indirect and in the allocation of direct and indirect costs to this project. So, for example, their overhead, those salaries that don't necessarily go to the project but are billed to some extent to the project. So you're going to want those. And then depending on who you are and what function you have and where you fit, it's going to depend. And if you want to ask more direct question or offline, I put my email into the chat.
Okay, just Ray has a question. I'm not sure if you want to take this
I'll
since.
read it.
Okay.
I like that language. So they're not going to, I like the language, but they're not going to ever waive all liquidated damages unless they make sure that any waiver of all liquidated damages is a result that it's a no fault. But that's you can try that one.
Thank you. If materials and products are requested and contractor advises on another product just as good and you should use, you agree, but later find the reason for the change suggestion is the contractor had no experience with your choice, then you find the suggested material is not a reliable long term. Is that not detrimental reliance and therefore contestable without another change order in order to preserve the contract relationship?
Okay, hold on. That's a good one. I'm reading it again, sorry.
No worries.
Wow. So in this case, what I would do is if they tell you to use something different, they're amending the contract. So they have to have it in writing that they suggested this change. Otherwise, I wouldn't move forward. And you're relying on what they're telling you as the prime. So I would have, before I implemented those changes, I would have the the prime do a change order. I would have the architect and the engineer or whoever sign off on it before they moved ahead. Um, and yeah, yeah, that one's difficult. Please email me offline.
Oh, I'm wondering if the specific insurance requirements in our contract are enforceable if they do not apply to our specific trade. For example, builder's risk insurance requirement included in our contract, but we are in the abatement company. We've had this issue in the past where our insurance company has extreme difficulty procuring this coverage for us since we do not run a real risk, but the awarding body will not waive this requirement.
Because they don't, they just, this is what they want, or these are the requirements that they can't deviate, even if it doesn't make sense. Um, I,
It,
you know, here's the thing. If the specific insurance requirements, the public entities are going to ask what they asked for, and or the primes are going to ask what they asked for, even if it doesn't make sense. In your shoes, I would make the case to, or have your insurance agent make the case to the risk management or the public entity to see if you could get some changes to what they're requiring since it doesn't apply to your trade. But beyond that, you can try.
if we're to audit our prime to ensure they're honest with their billing to us, what are some common areas of fraud with them or the subcontractors?
Okay, so some of the areas is that they are padding your billing. So, for example, with municipality or they are required they are allowed to do a markup, but that is usually codified in the text. Um, Not every public entity, but most public entities, all of the information of how much the prime was paid is accessible and online, and you can ask for it. So if it's a private project, then that is more problematic. And but what you could do is if there's a lender involved, you could go ask the lender what they are and areas of fraud. So the areas of fraud that I could see is that essentially that they are padding the bill that you submit. Um, yeah, that's about all I could see. I'm gonna do some research on that one.
I think we already responded to this. Can a JV aggregate their bond capacity?
Yes, they can in certain instances, but once again, it has to do um with how the JV is written. We want to make sure that the surety knows exactly what is going on and they have a full understanding of how you would be working together. Um, the more comfortable they are with your team, the better off they are.
If a subcontractor sub their installation and expects us to pay their sub directly, can you talk about how to navigate it? We only had a contract with the original subcontractor. Also, it was a public works job, so they have to submit certified payroll, and we only bid the project with the original subcontractor on our documentation.
Ooh, so essentially you don't have a contract with their sub. So what you could do is joint checks. Be, as would happen if, for example, if the subcontractor wasn't paying their suppliers or their material men, one way to around that is doing a joint check to make sure all the project is paid. And that's usually something that's allowable, but usually it's unusual that the third tier sub would be paid by the prime, since it is a public works job. Um, so I would see if the subcontractor would agree to going through them for third party payments. That's one way we've seen people get around this type of question.
Do all public works projects typically have a contract compliance officer? And if so, what is the best way to find out who it is without raising flags? Would this be someone to contact before proceeding with a stop notice?
So I would do it on both fronts. I always think it's better to do overkill than less. I would Google the contract compliance officer, and usually the way you find a contract compliance officer or someone with a similar title, because it's not always the same thing, is when you have the original advertising of the project. If you can locate that, it will say who the project manager is and who the sub is, who the contract compliance officer or the enforcement officer, and so you can start there. With a stop notice procedure, I would Google that directly for wherever you are and just go ahead and do it. Because I just think that if, you want to preserve your rights in all cases.
More audit information. There has been self-reported fraud by the prime construction company, specifically a sub invoices being altered by the prime. Given this, what information should we ask the prime and their subs to do a full audit?
So you're going to want to know all the certified payroll, and you're going to want all progress payments, and you're going to want what the prime submitted to the owner, and you're going to want what the sub submitted to the prime to do a full audit.
Friends of Watts Tower just wanted to say your response was great, adequate, detrimental, reliance inquiry. Thank you. Or
You're
thanks.
welcome.
Who holds responsibility for the accuracy of project technical documents? I've been seeing documents where the GC requires that the subcontractors review and are responsible for the accuracy of information provided by the GC. Would it be better for the GC to warrant that information they are providing is correct? To warrant that the information they're providing is correct. Under the circumstances, would a subcontractor appropriately be responsible for verifying accuracy?
So this is just another way for the GCs to do risk mitigation and push the risk down to the subcontractor on something that they should be, my opinion, technically responsible for. One of the ways is you should review the project technical documents and make sure that you've reviewed them for accuracy. And then from your knowledge on how that scope works, make sure that they're accurate. And then every time they're inaccurate, I would call it out in writing. If this is what they've done, but if you have a contract with that, I would see if you could push back and get that removed.
Follow up on the subcontractor sub question. We did not want to pay their sub and now we're considering legal action.
Right. That is one recourse to take. Depending on what your contract said. And so they are responsible for their subcontractor and paying them.
Beautiful. We have another individual who said thank you. We, as the subcontractor, were awarded a bid for a roof repair. We included certified payroll costs, labor materials based on the days it would take us to complete the work. Does this sound like we're on the right track as far as the prime including this in the contract bid?
Okay, so you in this instance are the subject matter expert. And if you feel comfortable with all of your scope of work and estimate and that you can actually do it in the time and that you have considered all general condition matters, then you should be okay. And it sounds like you're on the right track, um, including this in the contract bid. But make sure you don't leave anything on the table.
That one was my question. Can we just say you should be responsible for the accuracy of information? Don't push that on us.
I wish you could. And if you can and you and they're okay with it, I'm okay with it too. Yeah, honestly, they should be responsible for the accuracy of information. You're bidding on it, and yes, as subcontractors, you have an expertise in your scope of work, but in terms of the prime documents, in terms of the prime contract, they're delivering the contract. See if you can try it. Maybe um, instead of you should be responsible for the accuracy of the documents, just say in our estimation, um, it is unlikely that we will be able to be responsible for the accuracy of information and documents because we have a limited scope.
Thank you. We have a question from the chat on if you have any recommendations for any AI legal document or legal review.
I apologize. I don't have any recommendations, but I'm going to start adding that to my list. And I like using it myself, just Chat GPT for right now.
Okay. Is there anyone else who had any additional questions? These are all the questions that I've seen in the chat and in the Q&A.
Hold on, don't close it yet. I'm taking some. Is the chat there later?
I can send you the information. Don't the
Okay.
questions that yeah, don't worry
Yeah, the
about it.
questions and the chat if you can, except for that one lovely gentleman.
No worries. Okay, we have a thank you slide, and then oh, we have two questions, sorry. Could
Okay.
you speak a bit about the risks of using AI for legal review? What are some things that you can be confident it will do it acceptably? What are some things you should not trust it to be accurate on?
So yeah, that's a really so anytime you use something like AI, the what you put into it is what you get out of it. And I think sometimes if you don't ask the right questions, and it is a learning curve tool. So it's a little bit that you're going to have to learn. And so in my estimation, the best way to do it is to find two AI legal review chats and then compare them to each other to get a level of comfort until you've built up your knowledge to help yourself. That was helpful.
And how do we contact you individually? So Jennifer, I think, has placed her email in the chat there after. Let me get to the survey page and then I'll go through that with you
Okay,
guys.
good. Thank you, Rena.
So first, I want to say thank you to our wonderful presenter, Jennifer, for taking time out of her afternoon to come and go over legal review with us. I know it's a topic where it's hard to find individuals who are willing to really sit down and talk to you about it. If there are any in-depth questions that you have, I advise everybody to enroll in the program. I'm putting the survey link in the chat right now, as well as sharing my screen with it. A few things are going to happen after this webinar. First, you will receive an email with a checklist that Jennifer has put together, today's presentation, as well as a recording of the presentation that's edited. Second, if you are eligible to enroll in one of our programs and you have attended today's session, you should receive an enrollment form for the program that you're eligible to enroll in. And if you have specific questions or want to just sit with someone and kind of talk about your business, That would be your best opportunity to get connected with a contractor development manager. If you have specific questions for Jennifer, you're welcome to email Jennifer, and it is up to Jennifer's discretion if she can meet with you or things like that. However, the first step would be to talk to your contractor development manager. And depending on the level of their issue, they could either connect you with Jennifer or Jennifer could connect with you herself. Can we contact Jennifer individually? Jennifer is saying that you are more than welcome to email her, but if you want someone who is dedicated to your business who can respond to you promptly about that, please enroll in the program so we can get you connected with a contractor development manager. Jennifer, there's a comment. Jennifer, you are one smart cookie. Thank you so much. Seriously. Email, I think I got all the questions in the Q&A. Please, please, please fill out the survey. The survey provides us invaluable feedback on how these joint sessions are going, topics that we should be focusing on. The survey link is in the chat as well as on the QR code screen in front of you. After you finish completing the survey, watch out for those emails, and we hope to see as many of you as possible enrolled in the program. If not, after you've completed the survey for today, I wish you a good afternoon. Thank you so much for joining us this month for our contract review session. We'll see everybody next month for change orders. The invites for that should be going out. It should be posted to our Eventbrite shortly.
Bye, guys.
Bye, Jennifer. I'm going to stay on for a couple more seconds and then make sure everybody is good. You're more than free to leave after you've completed the survey. For those of you asking for Jennifer's email, I placed it in the chat. All right, everyone, I'm going to log off. Everyone have a good afternoon. No one else needs anything? Okay, have a good afternoon, everybody.